Both applicant and the government seem to agree that these records were held on to largely beyond the maximum retention period of 12 months. But the government says that that is not their concern, that this is the responsibility of the telecom operators. First of all, that is completely incorrect. What really happens is that the telecom operators, they gather these data, and when the maximum retention period is approaching, they transfer these data to BTK, which is a government institution, and it is then BTK which holds on to these data beyond the maximum retention periods. But even if you would follow the Turkish reasoning, then still such reasoning would be way too easy, because that would mean that states would just outsource all their illegal activities to private players and never be held accountable. And that would violate Article 5 of the ILC draft articles on state responsibility, but also go against the jurisprudence of your court, notably the Mutu and Pechstein versus Switzerland case. Moreover, holding on to illegally obtained data, which then the government eventually did, is a crime under Turkish law. Articles 135 till 138 of the Turkish Criminal Code. And the Turkish Constitution and the Turkish Code on Criminal Procedure explicitly provide that a criminal conviction can never be based on illegally obtained evidence, which happened in the present case. The second reason why the BILOG data violate Articles 6 and 8 of the Convention is the fact that we have no idea at all as to how they were gathered and how, consequently, their integrity was preserved. As to the way these data were gathered, we have multiple explanations. The judge, in first instance, in the present case, considered that these data were bought of Lithuania. But other documents claim that these data were stolen by MIT officials who went to Lithuania. In any event, however it may have happened, one thing is sure today is that we have no idea at all as to how these data have ended up, if they have ended up in the hands of MIT, how they have ended up there. And this cast a shadow of unreliability over the data in their entirety. And the same applies with regards to the way they preserve these data. The only thing we know for sure is that these data have been tampered with. In this regard, one can take a look at the report, the expert report of Professor Baha Sen and digital forensics expert Rafet Ongokmen, both appointed by Turkey itself, who confirm that the data have been manipulated on the 26th of October 2016 before there was even a court order. So even if today the government would suddenly come up with these original BILOG data, there is still no way to satisfy the chain of custody requirements that your court requires with regards to such data.